If you ask me what the sweetest kind of revenge feels like, I won't tell you it's the moment someone cries. Tears are cheap. Anyone can cry. The sweetest revenge is quieter than that. It's the sound of a folder closing. It's the silence after you've said the last sentence and nobody in the room can find a rebuttal. It's walking into a courtroom in a coat you bought with your own money, past a man who once told you that you would never own anything worth owning, and using the very law he built his life on to take that life apart, piece by piece, in front of witnesses. My name is Naomi Voss. I am 34 years old. I am Chief Litigation Counsel at Ashcroft Reyes, one of 4 law firms in this country that Fortune 500 boards call when they are about to lose something that matters. In 9 years of practice, I have tried 211 cases. I have lost 4 of them, and I remember every single one, because losing is the only thing that ever taught me anything. Today is an anniversary, though no calendar marks it. 10 years ago, almost to the week, I stood in a penthouse living room on Park Avenue and listened to a woman in a cashmere cardigan explain, over a china teacup, exactly what I was worth. Today, I am walking into courtroom 4B of the United States District Court for the Southern District of New York to face her son across a conference table for the first time since the night it ended. The case itself is not complicated, not on its face. My client is Solara Kinetics, a Brooklyn-based electric vehicle startup with a battery architecture that 3 larger manufacturers have spent 2 years and $40 million trying and failing to replicate. Solara is in the final stage of a technology licensing and joint manufacturing agreement with Bergmann Industry, a 130-year-old German auto conglomerate that wants Solara's battery patents badly enough to have flown 4 vice presidents to New York twice this year alone. On paper, this should be simple. Bergmann wants the technology. Solara wants capital and a global manufacturing footprint. Both sides need each other. But the contract Bergmann's U.S. counsel has put in front of my client is not a partnership agreement. It is a leash with a bow tied on it. Staggered technology transfer payments, structured so Solara bleeds cash for 18 months before receiving a cent. A reversion clause that hands Bergmann ownership of any future improvements Solara's own engineers develop, in perpetuity, worldwide, no compensation required. An exclusivity clause so broad it would legally prevent Solara from ever licensing to anyone else, even after the contract term ends, under language buried in a definition section nobody reads. 6 law firms in New York looked at that contract, looked at who drafted it, and declined the case. Not because the case was weak, because of who was on the other side. Grant Halloway, 35 years old, managing partner at Halloway & Pierce by the time he was 31, the youngest in the firm's 90-year history. The trade press calls him the surgeon, fast, exact, and, until this morning, undefeated in any cross-border deal he's personally led. He has closed more than 90 international acquisitions. He has never lost a negotiation he was willing to drag out long enough. I know his method because I used to watch him build it, back when we studied for the same exams at the same library table. Delay. Never argue the merits when you can argue the calendar. Bleed the other side's patience until they sign whatever you put in front of them, just to make the bleeding stop. Solara's production line has been calibrated and idle for 4 months, waiting on these German blueprints. Every week of delay costs my client a number with 6 zeros in it. Gramps has run this play 100 times. It has never once failed him. It is going to fail him today. At 8:40 a.m., I walked my team into courtroom 4B. My associate, Priya, laid out our binders on the plaintiff's table one at a time, 19 of them, each with a different colored tab, in the exact order I would need them, and not one page out of place. She leaned toward me and murmured, "Gallery's full, front 3 rows." I already knew. I could feel it before I looked, that particular hum a room gets when it thinks it's about to watch a formality. I let my eyes move once across the gallery. Halloway and Pierce Associates, junior partners, a reporter from a legal trade paper who covers big M&A the way other reporters cover heavyweight boxing. And in the center of the second row, in a cream Chanel boucle suit, her hair set into the same architecture it had been in 10 years earlier, a woman sat with her ankles crossed and her chin very slightly lifted, studying me the way you'd study a used car you had already decided not to buy. Eleanor Halloway, Grant's mother. The real engine behind Halloway and Pierce for 3 decades, ever since her husband died and left her a firm instead of a fortune, and she turned it into both. The woman who, 10 years ago, stood in her own living room and told me, without raising her voice once, that I did not belong in her family. She had not changed. She had simply calcified into a more expensive version of herself. She was here, I understood, the way you go to watch a coronation. She thought this case was another guaranteed win for her son, and she had come to enjoy the show. I unscrewed the cap of my water bottle and took a slow sip. Priya leaned in again. Halloway's lead, keeps looking over here. Let him look, I said, and did not look up. At 8:50, the clerk called the room to order. 3 judges entered. This was a panel matter, given the size of the dispute, led by Judge Miriam Castellano, a woman in her 60s with silver-streaked hair pulled back so tightly it looked like it hurt, and a reputation in the contracts bar for being the single hardest judge in the district to get anything passed. She struck the gavel once. Be seated. Solera Kinetics versus Bergman Industry North America. Contract dispute and related claims is now in session. We will begin with identification of counsel. Halloway and Pierce stood first. Grant wore charcoal, tailored so precisely it looked less like clothing than like architecture. His tie a deep burgundy, his hair combed with the same care I remembered from a decade ago, as though he still believed the world responded to a good part in the hair the way it responds to a good argument. He rose, and, out of habit or arrogance or both, he glanced toward the plaintiff's table with the easy half-smile of a man checking that his audience was watching. Your Honor, Grant Halloway, lead counsel for the defendant, Bergman Industry North America, and managing partner at Halloway & Pierce. My credentials and authorization letter have been submitted to the clerk. The bailiff carried the documents forward. Judge Castellano reviewed them, nodded, and turned to our table. Counsel for the plaintiff. I stood. I felt it happen before I even finished rising. The exact half-second in which recognition crossed Grant's face and something behind his eyes cracked. The way a windshield cracks from a stone thrown at highway speed, one small point of impact spreading outward into 100 fine lines. He knew me. Of course he knew me. What he had clearly never once imagined, in 10 years of building an unbroken record, was that he would meet me here, like this. I wore charcoal, the way he did, because I had learned a long time ago that if you are going to walk into a man's world, you do not walk in asking permission to match his register. You simply match it. My hair was pulled back off my face completely, nothing left to soften the lines of it. 10 years had sharpened my jaw and settled something into my eyes that had not been there at 24. In the second row, I watched Eleanor Holloway's grip on her handbag falter for just a moment before she caught herself. I did not look at either of them. In a voice pitched neither high nor rushed, I said, "Your Honor, Naomi Voss, lead counsel for the plaintiff, Solara Kinetics. Bar number 4471029. My firm is Ashcroft Reyes, New York office. Authorization and credentials are with the clerk." Judge Castellano reviewed the papers, glanced up, something flickering across her face that might have been curiosity. "Ms. Voss? I don't believe I've seen you in this courtroom before." "You haven't, Your Honor. This is my first appearance in this district." I let a beat pass, and then, because I had earned the right to enjoy exactly one small moment of theater before 6 months of work took over, I turned my head very slightly toward the defense table and added, in the same even tone a person might use to comment on the weather, "But I've been preparing this case for 6 months." Grant's throat moved as he swallowed. The certainty that had been sitting on his face like a coat that fit perfectly began, very quietly, to come apart at the seams. "Very well," said Judge Castellano. "Let's proceed to opening statements on the record. Plaintiff, you may state your claims." I stood and I picked up the first folder, and for the first time in 10 years, I let myself feel exactly how good it was going to feel. "Your Honor, our claims are as follows. First, we ask this court to find that the defendant, through its United States counsel, engaged in bad faith negotiation and commercial misrepresentation during the course of these dealings, and to order compensation for the resulting damages to our client. Second, we ask the court to find that the standard agreement proposed by the defendant contains multiple unconscionable and predatory provisions, and to void them as a matter of law." I paused and lifted my eyes to meet Grant's directly for the first time in 10 years. Third, we have documented evidence that defendant's lead counsel, Mr. Holloway, is operating under an undisclosed and disqualifying conflict of interest, and we move this court to remove him from representation in this matter, effective immediately. The gallery erupted. 2 associates from Holloway and Pierce actually stood up. Eleanor Holloway's voice cut across the noise before the gavel could. "That is a lie!" Judge Castellano brought the gavel down twice, hard. "Order! One more outburst from the gallery and the bailiff will clear this row." Grant was on his feet, his face gone the color of paper. "Your Honor, I object. Counsel is making a slanderous accusation on the record without offering a shred of evidence. I demand she substantiate it." "I intend to," I said, before the judge could answer for me. "Your Honor, may I approach with the first set of exhibits?" Judge Castellano nodded. "Proceed." I opened the second folder, the one with the blue tab, and Priya carried the copies forward to the bailiff. "Your Honor, Plaintiff's Exhibits 1 through 5. Exhibit 1 is a memorandum of engagement dated March of last year, retaining Holloway and Pierce, specifically Mr. Holloway personally, as outside counsel for Ferrovia Motion, a New York-based EV drivetrain company and a direct competitor of our client in the exact battery-adjacent technology space at issue in this contract. Exhibit 2 is a set of internal engagement logs from Holloway and Pierce, showing that Mr. Holloway billed time to Ferrovia Motion between January and April of this year, the same window in which he was simultaneously negotiating this agreement, on Bergman's behalf, against my client. I let the judge take her time with the pages before continuing. "Your Honor, under the American Bar Association's Model Rule of Professional Conduct 1.7, A lawyer may not represent a client where that representation creates a concurrent conflict of interest with another client, absent informed written consent from both parties. No such consent exists here. Mr. Holloway was, during these negotiations, being paid by a company that competes directly with my client in the same narrow technical field for work he has characterized in his engagement letter as general commercial strategy consulting, not employment law, not litigation support, commercial strategy. Grant's mouth was pressed into a thin line. A fine sheen had appeared on his forehead under the courtroom lights. Exhibit 3, I continued, opening the third folder, is a comparison chart my team prepared cross-referencing the 11 successive drafts of the Bergman-Solera agreement produced over the past 6 months against Ferrovia Motion's own supply and licensing terms, which were disclosed in an unrelated SEC filing last year. Your Honor, 7 of the most aggressive and unusual clauses in the Bergman draft, the reversion clause, the staggered payment structure, the worldwide perpetual license back, appear nearly verbatim in Ferrovia's own standard licensing paperwork. Paperwork that predates this negotiation. Paperwork that Mr. Holloway had direct access to during the exact period he was also drafting terms for Bergman. I closed the folder and looked at Grant directly. Your Honor, this is not merely a conflict of interest. This pattern is consistent with the improper use of one client's confidential commercial strategy to benefit another, adverse client, conduct that, depending on what further discovery reveals, may also implicate federal trade secret statutes. We are not asking the court to find fraud today. We are asking the court to disqualify counsel today, and we are reserving our right to refer this matter to the appropriate regulatory bodies. The courtroom had gone so quiet I could hear the air conditioning cycle on. Grant's associate rose halfway out of his chair, his voice cracking on the first word. Your Honor, we request a recess to review these documents. Judge Castellano did not answer him immediately. She looked at the exhibits, then lifted her eyes and studied me for a long moment, the particular look of a veteran jurist recalibrating how seriously to take a lawyer she has never heard of. Then she turned to Grant, her tone sharpening. Mr. Holloway, opposing counsel has submitted documentary evidence of a potential conflict that goes directly to your eligibility to remain lead counsel in this matter. I'm required to question you on the record. Is what Ms. Voss has represented accurate? Grant took a breath that was supposed to look composed and did not quite land. Your Honor, I did provide limited advisory services to Ferrovia Motion during that period, but my engagement was narrowly scoped to executive compensation structuring, not commercial strategy. I had no access to and did not use any of Ferrovia's proprietary licensing terms in drafting the Bergman Agreement. Ms. Voss's argument conflates two unrelated engagements to manufacture the appearance of a conflict that doesn't exist. I almost laughed. He hadn't changed at all in 10 years. He still had 100 ways to make himself clean, even standing directly in the wreckage of something he'd built with his own hands. It was his mother who had once, in front of an entire room, told me exactly what I was worth. And afterward, he had told me she just worried about him, that I should let it go. It was he who ended things with a check pressed into my hand like a tip, and afterward, apparently, he had told people he'd been generous. Grant Holloway, you are exactly the man you were 10 years ago. But I am no longer the girl who went quiet the second you raised your voice at me. Your Honor, I said, I'd like to submit our second set of exhibits marked 6 through 8. Priya carried the thin folder forward. Exhibit 6 is a certified transcript of 3 recorded phone calls, along with the original audio on a disc for the court's review, dated the 11th of January, the 3rd of February, and the 22nd of February of this year. The 2 parties on these calls are Mr. Holloway and Ferrovia Motion's then Chief Commercial Officer, a Mr. Owen Reyes Park, no relation to my firm. I watched something in Grant's expression finish collapsing. "These recordings," I said, "make clear that Mr. Holloway was briefed in detail on Ferrovia's licensing architecture, including a document Mr. Reyes Park refers to on the second call as the reversion structure we use to keep the upside if a partner improves on our tech. That structure, Your Honor, appears in the Bergman Agreement drafted for our client 6 weeks later, essentially word for word." Eleanor Holloway shot up from her seat in the gallery. "You're inventing this. Where did you get recordings of a private call?" Judge Castellano's gavel came down 3 times, hard enough that the sound cracked through the room like a rifle shot. "Bailiff, remove that woman from the gallery." 2 bailiffs moved toward Eleanor Holloway. She wrenched her arm away from the first one, her voice climbing. "On what grounds do you know who I am?" "I know exactly who you are, ma'am," Judge Castellano said without looking up from the exhibits. "You are a member of the public gallery who has now interrupted these proceedings twice. Escort her out." They walked her out through the double doors at the back, her heels striking the marble floor in the hallway in a rhythm that, 10 years ago, would have made my chest tighten with something close to fear. Today, it only made me want to check the time, because I had 6 more folders to get through and a very full afternoon. Judge Castellano set down her pen. "Mr. Holloway, given the documentary and recorded evidence submitted, this court finds sufficient basis to question your continued eligibility as lead counsel in this matter. I am granting plaintiff's motion to disqualify, effective immediately, pending a formal referral to the New York State Bar Disciplinary Committee for further review. Bergman Industry North America will need to secure new counsel of record within 14 days. We are in recess until 1:30. The gavel fell. Grant did not move. He sat there with both hands flat on the table, staring at a spot somewhere past the edge of it, while his associates gathered the binders around him in a silence no one seemed to know how to break. I closed my last folder, and for the first time all morning, I let myself think about the night, 10 years ago, when I had believed a man like him could ever have chosen someone like me over the woman who raised him. I met Grant Holloway in a lecture hall at Columbia Law, in a contract seminar taught by a professor famous for making first years cry. I was 22, on a partial scholarship that still left me waiting tables 3 nights a week at a diner in Morningside Heights, wearing the same 3 sweaters in rotation because laundry cost money I didn't have to spare. He was 23, already a Holloway, already the kind of person professors called on first because they assumed, correctly usually, that he'd done the reading twice. I noticed him the way you notice weather. Impossible not to. What I did not expect was for him to notice me. It happened during a case discussion on a doctrine most of the class treated as a formality, the rule protecting an innocent third party who buys property without knowing it was already promised to someone else. I raised a point about how the doctrine gets twisted in practice to protect sophisticated buyers who should have known better, people who structure their ignorance on purpose so the law will reward it. The microphone in that hall had been broken for a week. My voice landed somewhere around the 4th row and died there. I was sure no one behind me had heard a word of it. Grant had heard every word. He found me after class in the hallway, said my analysis was sharper than anything he'd read in a bar prep outline, and asked, with a kind of straightforward ease I wasn't used to from anyone, whether I wanted to get coffee and keep arguing about it. I said yes, because I was 22 and he was extremely handsome, and I told myself it was about the argument. It became dinners, then study sessions that stopped being about studying an hour in, then long walks across the Brooklyn Bridge at midnight because he liked to point out the skyline like he was introducing me to family. He was witty in a way that never punched down, generous with his time in a way that never felt like performance. He had grown up wealthy, had gone to every good school New York had to offer, and yet he never once made me feel the distance between his life and mine. If anything, he seemed to work at closing it. He dressed down when we were together. He never once let a bill land in a way that would embarrass me, and he never made a show of paying it either. I thought it was thoughtfulness. My roommate at the time called it winning the lottery. He's gorgeous, he's loaded, and he picked you out of an entire law school full of women who would have crawled over broken glass for him. I told her not to be dramatic. Privately, I agreed with every word. He told me, on the bridge, one night in October, that he was going to be the best deal lawyer in New York, that he'd buy a building with his name on the top floor, and that I could be his partner. I laughed and told him I'd never work for anyone, least of all him, that I was going to finish my degree, open my own firm, and specialize in taking the cases his firm was too afraid to lose. He pinched the bridge of my nose the way you'd tease a little sister and said, "Fine, I'll see you in court then." I believed completely that we were going to walk toward that future together. In the spring of my final year, I began applying for postgraduate fellowships and clerkships, chasing something bigger than the associate track everyone assumed I'd take. Grant helped me revise my personal statement so many times, the margins turned into a second document, entirely in his handwriting, arguing with my sentences until they were better. When the offer came through, a 2-year appellate fellowship under a federal judge known for producing future Supreme Court clerks, a fellowship that paid enough that I could, for the first time in my adult life, stop counting the exact dollar amount of everything I ate. I sat on the floor of my studio apartment and cried for an hour before I could even call my mother. My mother had worked a factory floor for over 20 years by then, on her feet from 6 in the morning until she came home smelling like machine oil at 10 at night, sending every spare dollar my way since the day my father died. When I told her, she sobbed on the phone. "You did it, Naomi. Your dad is watching. He has to be watching." Grant was, if anything, more excited than I was. He took me to a restaurant that cost more than my monthly rent to celebrate, raised a glass and said, "I knew you'd do it. You're the smartest person I've ever met." I told him I only had 2 years left before I'd be back for good. He said, "Of course. Who else would I be waiting for?" That was the happiest night of my life before I turned 23. And then the rain started. Before any of it, before Grant, before Harvard, before a China teacup taught me exactly how little some rooms thought I was worth, there was my mother. And there was a factory floor in Allentown, Pennsylvania. And there was the particular arithmetic of a household where every dollar had already been spent 3 times over in someone's head before it ever actually arrived. My father died when I was 16. Officially, a heart attack, sudden, at home, on a Sunday morning while he was making the same eggs he made every Sunday morning of my childhood. Unofficially, and this is a distinction I did not have language for until much later, he died of the particular slow damage that comes from watching something you built with your own hands fail for reasons you can't understand, month after month, until your own heart simply runs out of whatever it takes to keep absorbing that kind of confusion. Voss Fabrication had been his, not inherited, not funded by anyone else's money, built from a single rented machine shop and a loan he spent a decade paying off. When Kessler Marsh terminated their contract, citing quality failures an independent audit later proved never existed, 3 other clients followed within the year, spooked by the rumor before anyone had bothered to check whether the rumor was true. My father spent his last 18 months trying to understand what he'd done wrong, running his own inspections over and over, unable to find the flaw everyone insisted was there, because there was no flaw to find. He never got the chance to learn that the failure had never been his. He died believing his own hands weren't good enough, and there is no version of what happened afterward that gives those 18 months back to him. My mother went to work on the factory floor 11 days after the funeral, because grief, in our house, was a luxury item we could not carry alongside rent. She had never worked outside our home before that. She'd kept our books, run our small household with the same careful precision my father brought to his machine shop, and she adapted, at 44, to 12-hour shifts on a line assembling components for appliances neither of us would ever be able to afford ourselves, with a speed and a stoicism that I did not fully appreciate until I was old enough to understand what it costs a person to reinvent themselves entirely, overnight, with no time allotted for the reinvention to hurt. I remember the sound of her key in the door at 10 every night, the particular exhausted rhythm of her footsteps, the smell of machine oil that never fully washed out of her work clothes, no matter how many times she ran them through the laundromat 2 blocks from our apartment. I remember her sitting at our kitchen table after midnight some nights, going through my homework with me anyway, insisting on it, because she had decided, somewhere in those first terrible months after my father died, that the single thing she still had full control over was making sure I got out of Allentown with a diploma that meant something. She never once, in all the years I watched her come home with her feet swollen and her hands cracked from solvent, said a single word of complaint in front of me. It was only much later, going through her things after she died, that I found a small spiral notebook tucked behind her nightstand, filled with her handwriting. Not a diary, exactly, more a kind of ledger of feelings she'd allowed herself only on paper, where I wouldn't see it. Entries like, Naomi got an A on the mock trial brief today. Told her it was good. Wanted to tell her it was the best thing I've ever read, but didn't want her to think I was exaggerating out of love instead of really meaning it. And dated a few months before I left for Columbia. I am so tired today I can barely hold this pen, but she doesn't know that, and she is never going to know that, because the day she starts worrying about me instead of about her own future is the day I have failed at the only job I have left. I think about that notebook often now, watching my own children grow up in a life so different from the one I had that it sometimes feels like a story I'm telling them rather than a history either of us actually shares. Teo has never once had to wonder whether there would be enough for groceries. Iris has never had to choose between a school trip and a winter coat. I built that distance on purpose, every year of it, and I am proud of it in a way I don't apologize for to anyone. But I also make sure, deliberately, on purpose, every single year, that they know exactly whose hands built the floor they're standing on. Not mine alone, my mother's first. Cracked, calloused, exhausted, and never once, not for one single day of her life, treated by the people who mattered most to her as anything less than extraordinary. When Eleanor Holloway sat across from me in her living room and asked whether a girl from that kind of family was suited to marrying her son, she was, without knowing it, insulting a woman who worked harder in a single decade than Eleanor had ever been required to work in her entire gilded life. I did not have the language at 23 to say that out loud in the moment. I have had 10 years since to build every ounce of language I would ever need. I remember the date because I have replayed it so many times it's worn smooth, the way a stone gets smooth from a hand running over it too often. March the 14th. New York was having one of those late winter cold snaps that feels personal. Wind coming off the river like it had a grudge. Grant had asked me to come to his mother's for dinner. Officially, he said, like there had been an unofficial version I'd already passed, because Eleanor wanted to finally meet the woman he'd been talking about for a year. I spent 4 days preparing for that dinner the way I would later spend 6 months preparing for a Supreme Court amicus brief. I tried on every piece of clothing I owned, in every combination, and finally settled on a pale gray sweater dress I'd bought on a 60% off rack, which had still cost me almost a full month's grocery budget. I bought a bouquet of white carnations at a bodega on the way, because someone had told me older women liked them, and because I did not yet understand that the Halloways did not receive flowers from bodegas. Their apartment took up the entire top 2 floors of a pre-war building on Park Avenue, the kind with a doorman who calls up before you're even allowed near the elevator. The living room alone was bigger than my entire studio, with a crystal chandelier that threw small rainbows onto floor-to-ceiling oil paintings and leather furniture so soft it seemed to apologize for existing near me. Eleanor Holloway sat in the exact center of the sofa, like she'd been placed there by an interior decorator. A cashmere cardigan draped over her shoulders, her hair set into a style so precise it looked less like grooming and more like architecture. Beside her sat a man I didn't recognize, a senior partner from the firm named Whitlock, there, I would understand later, specifically to witness. I set the carnations on the coffee table and held out my hand. "Hello, Mrs. Holloway. I'm Naomi." She looked at the flowers the way you'd look at a stain on a tablecloth and did not take them. Instead, she looked at me, slowly, from my shoes upward, taking her time, and I understood, in that single, unhurried inventory, exactly how the rest of the evening would go. It wasn't hatred in her eyes. Hatred I could have handled. It was something colder and more efficient than that. Disdain. The specific look of a woman appraising an item in a store window she has already decided, before even asking the price, that she will never buy. "Naomi Voss," she said finally, setting the name down like she was testing whether it would hold weight. "Grant mentions you. Sit, please." I sat with my knees together and my back straight, the way you sit when you're worried the furniture is judging you too. Grant sat beside me, an arm along the back of the sofa, and said with a bright, protective smile, "Mom, don't be so formal. You're making her nervous. You should hear about her. She just got a full scholarship offer for a 2-year federal appellate fellowship. Do you know how competitive that is? People kill for that." Eleanor lifted a porcelain teacup from a low table, took a slow, unhurried sip, set it down without a sound, and looked at me the way you'd discuss unpleasant weather. "Ms. Voss, I know a little about you and Grant. It's normal at your age to date, to have fun. But Grant is about to be made partner at the firm his father and I built from a single office on Lexington Avenue. It will be his one day." She let that settle, a faint curve appearing at the corner of her mouth. "Do you think a young woman from your kind of background is suited to being the wife of the man who runs that firm?" Your kind of background. 4 words, and I felt them land exactly where they were aimed. My mother had stood on a factory line for 2 decades, her feet so calloused she couldn't cut them with regular scissors anymore. Up at 5, home at 10, every spare dollar funneled toward a daughter who was, at that exact moment, being told by a woman worth more than my entire hometown that her sacrifice amounted to that kind of background. My hands curled in my lap, nails cutting small crescents into my own palms. My face, I made sure, showed nothing. I had already learned by 23 never to hand an enemy your wound. Grant was the one who got angry first. "Mom, what is that supposed to mean? Do you know how hard she's worked? She got this fellowship on merit. You know how many people applied and didn't get it? I didn't even get an interview for the one I wanted." Eleanor didn't so much as blink. She took another sip of tea, unhurried as ever. "Merit is fine for getting into a good school, Grant. It isn't a substitute for what runs a firm like ours. Background, connections, the right rooms. Which of those does she bring? She'll finish her fellowship and go be somebody's very talented hired lawyer. What you need is a wife who can manage your image, your relationships, the people who actually decide whether this firm survives another decade, not an employee with excellent grades." She turned to me then, something unreadable moving behind her eyes. Irritation, maybe, or a kind of pity dressed up as candor. "I'm not looking down on you, Miss Voss. I'm simply being honest, because someone should be. Our clients are worth hundreds of millions of dollars, some of them billions. Picture Grant bringing you to one of our events. Another partner's wife asks what your parents do. What do you tell her? That your mother works a factory floor? Do you understand what that does to him in a room like that?" Every word she said was delivered as lightly as small talk, and every word found the exact place I was most afraid of. I opened my mouth to answer and found I had nothing to say. Because, and this was the part that hollowed me out, everything she'd said was, in its own cruel arithmetic, technically true. My mother did work a factory floor. My family had no connections, no old money, no rooms we'd ever been invited into. Apart from an acceptance letter I hadn't even physically held yet, I had nothing to my name. Grant's face had gone red. He stood up fast enough that his knee caught the coffee table and rattled the teacups. "Mom, that's enough. I'm not marrying a resume, I'm marrying a person." Something shifted in Eleanor's expression. The first real crack in her composure all evening. She set her teacup down hard enough that it clattered against the saucer. "You're marrying?" she said. "No one told me there was a proposal." "There will be," Grant said, and I remember how my heart lifted at exactly the wrong moment, right before it all came apart. "I already know what I want." Eleanor stood, smoothing her cardigan with two precise motions, and looked at me with something that had finally hardened into open contempt. "Ms. Voss, I think it's best you understand something before this goes any further. This firm has survived 3 recessions and a hostile takeover attempt because every decision in it has been made with clear eyes, not sentiment. I will not watch my son throw away 30 years of my work because a scholarship made him sentimental about a girl from a factory town. If you have any decency, you'll end this yourself before I have to." "Mom, I am not finished." Her voice, for the first time all evening, actually rose, and the room went cold in a way that had nothing to do with the March wind outside. "Ms. Voss, what did your acceptance letter cost you?" "Some tuition assistance, I imagine, a stipend. Do you know what it costs to keep a firm like this alive for 30 years? What I gave up to build something for my son to inherit? You will not stand in that." I stood up. My knees were shaking, but my voice, when it came out, surprised me by not shaking at all. "Mrs. Holloway, I never asked you for anything. I never asked Grant for anything either. If loving your son without a trust fund attached makes me unfit for this family, then I already know your answer, and I don't need you to spell it out twice. I picked up my coat. Grant caught my wrist at the door, his face a mess of things he clearly didn't have words for yet. Naomi, wait, don't listen to her. She gets like this. She'll calm down. Will she? I asked. He didn't answer, because we both already knew. I walked out into the cold with my carnation still sitting untouched on that coffee table. And I did not cry until I was 3 blocks away, where no window from that building could see me do it. I want to tell you, Grant fought for me after that. For a few weeks, it even looks like he might. He called every day. He showed up outside the library with coffee I didn't ask for, and apologies that all started with, "You have to understand my mother." I did understand her, better than he wanted me to. I understood that a woman who built an empire out of nothing does not hand it to her son with a stranger from a factory town attached to it. And I understood that Grant, for all his talk about marrying a person and not a resume, had never once, not one single time, told his mother she was wrong to her face and made it stick. 3 weeks after that dinner, I found out I was pregnant. Not with one child. The ultrasound technician had to say it twice before it landed. Twins, a boy and a girl, tucked in together like they'd already decided not to be separated from each other, ever, by anyone. I told Grant on a Tuesday, in the same diner where I still worked 3 nights a week, because I couldn't afford to take the night off, even to have the conversation that would decide the rest of my life. I remember he went very still, and then very pale. And then he said, Okay, we'll figure it out. In a voice that sounded like a man reading lines he hadn't memorized well enough. He did not tell his mother for 6 days. I know because he told me so, later, like it was a mark of restraint rather than cowardice. When he finally did, Eleanor did not scream. Eleanor never screamed. Screaming, I would learn, was for people who hadn't yet mastered more efficient tools. She invited me to her office instead of her home this time, a message in itself, and set a check on the glass desk between us before I'd even finished sitting down. $300,000, made out to me, signed in her own hand. Ms. Voss, she said, I understand there is a complication. I want to be direct with you because I respect that you, unlike my son, seem capable of hearing hard things without falling apart. This is enough to cover a private delivery, private care for 2 children for several years, and a fresh start somewhere you won't have to explain yourself to anyone. What it is not is an invitation into this family. Grant has a career that depends on the right marriage, the right image, the right last name attached to his. 2 children by a woman he isn't married to, from your background, at this stage of his career, that is a story the wrong journalist writes once, and Grant spends the next decade trying to unwrite. I am asking you to spare him that. I am asking you to spare yourself the years of being quietly, politely unwelcome everywhere he takes you. I looked at that check for a long time. Long enough that she must have thought she'd won already, because she leaned back in her chair with the particular ease of someone who has never once, in her adult life, doubted the outcome of a negotiation she initiated. Where's Grant? I finally asked. Does he know you're doing this? Grant, she said, knows I am handling it. He asked me to. I found out much later that this was, technically, a lie. Grant had not asked her to write a check, had not been in the room when she did, had spent that entire week telling himself he would find a way to make his mother accept me, instead of accepting that he would never make her do anything she hadn't already decided to do herself. But at the time, sitting across that glass desk with 2 heartbeats inside me and a check for $300,000 in front of me, I did not know that. What I knew was that he had gone 6 days without telling his own mother I was pregnant with his children, and that when it finally happened, he had let her handle it, in her office, on her terms, with her signature. I did not cry in front of her. I had learned that much, at least, from the first dinner. I picked up the check and I said, "I'll take this. Not because you're right about anything, because I'm not going to raise 2 children on principle alone, and you clearly won't feel a thing about giving it, so it costs you nothing to lose an argument you were never going to have with me anyway." I stood, and at the door, I turned back. "You told me, back in your living room, that I needed connections, background, resources, that a Harvard-caliber scholarship wasn't enough to make me worth anything in your world. I want you to remember exactly what you said, Mrs. Holloway, because someday I am going to make sure you regret every word of it out loud in a room you don't control." She laughed, a small, genuinely amused sound. "I do hope you find the time between diner shifts and diapers, dear." I walked out of that office with a check in my coat pocket and something new and very cold settling into the exact place where, an hour earlier, hope had still been living. Grant tried to see me twice more after that. The first time, I told him I was leaving the city to take the fellowship, true, though I didn't tell him where, and by then the federal judge who'd offered it had, with the discretion judges are famous for, quietly agreed to let me relocate the position to a satellite chambers 2 states away, no questions on the record. The second time, he stood outside my apartment in the rain, an actual, almost theatrical rain, the kind New York produces at exactly the moments you'd scripted if you were writing this, and asked me not to disappear. "I'm not disappearing," I told him through a half-open door, one hand resting on a belly that had just started, faintly, to show. "I am leaving. There's a difference. Disappearing is what people do when they're running from something. I know exactly where I'm going." "Naomi, I love you. I'll fix this with my mother, I promise. Just give me time." "You had 6 days to fix it before she put a check on a desk instead of letting you find your own words," I said. "I'm done waiting to see how much time you need, Grant. Go be great. I hear that's the family business." I shut the door. I heard him stand there for a long time before his footsteps finally moved away down the hall. And then I sat on the floor of a mostly packed apartment and let myself cry exactly once, hard, for maybe 10 minutes. And then I got up, because crying doesn't pack boxes and I had a bus to catch in the morning. That was the last time I saw Grant Holloway's face in person until the moment, 10 years later, that it went the color of paper across a courtroom. People imagine that a woman who ends up successful 10 years later had some hidden safety net the whole time, family money quietly waiting, a mentor who cleared every obstacle, a soft landing she's simply too modest to mention. I want to be honest about what those 10 years actually were, because the version where it was easy does a disservice to every woman living through her own version of them right now. I moved to Philadelphia because it was close enough to keep my federal fellowship and far enough that I would never run into anyone who knew the name Holloway on a street corner. I gave birth to twins, a boy first, 6 minutes later, a girl. Both of them furious and loud and somehow, from the very first hour, inseparable. In a hospital room where the only other adult present was my mother, who had taken unpaid leave from the factory floor to be there, and who held my hand through 14 hours of labor with the same calloused grip she'd used to hold everything else in her life together. I named the boy Theo, after my father, who had died of a heart attack when I was 16, 3 years after a small manufacturing business he'd sunk his savings into collapsed practically overnight, under circumstances no one in our family fully understood at the time. I named the girl Iris because it was the first flower name I found that had nothing to do with carnations. I finished my fellowship with a 9-month-old and a newborn. Not exactly 9 months old at the same time, since they were twins, but close enough that the math never once felt kind. I nursed one while reading briefs, with the other asleep on my chest. I wrote a habeas corpus memo that a federal judge later called, in an opinion, the most rigorous analysis this court has seen from a junior associate in a decade, while running a 102-degree fever from mastitis I hadn't had time to treat. I took the check Eleanor Holloway had written me, put $300,000 of it directly into a trust the twins couldn't touch until they turned 25, and lived, for the first 4 years, almost entirely on fellowship stipends and my mother's help, because I had made myself a promise the night I signed that check over into a bank account. I was never going to let anyone, ever again, say that Grant Holloway's mother had bought my future. She had funded my children's futures. Mine, I was going to build with my own hands, and I wanted the paper trail to prove it in case I ever needed to. Ashcroft Reyes hired me out of the fellowship as a 4th-year litigation associate on the strength of 2 amicus briefs and a recommendation letter from a federal judge who did not write recommendation letters lightly. I made partner in 5 years, faster than anyone in the firm's history except one person, a fact the managing partner liked to mention at dinners, not knowing, or perhaps not caring, that the other person he was comparing me to was Grant Holloway himself, whose name I had by then trained myself not to flinch at when I heard it in a room. I built a specialty, over those years, in exactly the kind of case big firms are too afraid to take. Conflict of interest actions, disqualification motions, cases against firms so large and so feared that smaller competitors wouldn't touch them for fear of future retaliation. I told myself, in the beginning, that this was simply where the interesting work was. It took me longer than it should have to admit the truth, which was that I had spent a decade quietly building the exact skill set required to dismantle a firm like Holloway & Pierce from the inside, one procedural motion at a time, and I had been doing it long before I had any specific target in mind. Some part of me had been sharpening a knife since I was 23 years old. I just hadn't decided, yet, whose name would be on the handle when I finally used it. Theo grew into a serious, methodical child who took apart the toaster at age 6 to understand why it browned unevenly and reassembled it correctly without help. Iris grew into a child who could talk her way out of any consequence and several she hadn't earned yet, and who cried during nature documentaries but never during scraped knees. Neither of them asked about their father for years. And then, around age 7, both of them asked at once, in the particular way twins have of arriving at the same question independently and simultaneously. I told them the truth, the age-appropriate version of it. Their father was a lawyer in New York. He and I had loved each other once, and things had ended badly, and it wasn't their fault. And it wasn't really his fault either, not entirely. It was more complicated than fault, I told them, though privately I did not believe that anymore, not fully. Theo absorbed this the way he absorbed everything, quietly, filing it away to think about later. Iris asked, with the directness only a 7-year-old can get away with, "Does he know we exist?" He didn't, not with certainty. I had never told him I was carrying twins, only that I was pregnant, in that diner, before either of us knew there were 2. I had let him believe, if you thought of it at all, whatever version let him sleep at night. I told myself this was mercy. I am not entirely sure, even now, that it was. 2 years ago, my mother died. A stroke, sudden in her sleep. The kind of death that at least spared her suffering and offered me nothing in exchange for the years she'd spent giving me everything she had. I flew back for the funeral with 2 10-year-olds in matching black coats I'd bought them the day before, because I hadn't had time to plan further ahead than that. And I stood at her grave and made her a promise I hadn't fully understood yet, that someday I was going to make the sacrifice she'd made mean something bigger than survival. It was while going through her things, a lifetime compressed into 11 boxes, which felt like its own kind of cruelty, that I found the folder. My father's business. The one that collapsed when I was 13, that he never talked about, that my mother only ever referred to obliquely, the way you refer to a wound that never healed right. It had been a small precision parts supplier, Voss Fabrication, based in Newark, doing subcontract work for larger manufacturers. In the folder, my mother had kept every piece of correspondence from the collapse, letters, a lawyer's note she never had the money to act on, and a single page that made my hands go cold when I finally understood what I was looking at. A termination letter from Voss Fabrication's single largest client at the time, cutting the contract without notice, citing quality concerns that an independent audit, commissioned by my father with money he didn't have, in a last desperate attempt to save the business, had found no basis for. The client's name meant nothing to me at 13. It meant everything to me now, sitting on my mother's bedroom floor at 32, because I recognized it immediately as a subsidiary, since folded into a larger holding structure, of a company whose parent entity, 3 ownership layers up, on the very first page of a public SEC filing I would pull up 18 months later during discovery on an entirely unrelated case, was listed as a long-standing private client of Halloway and Pierce. People who meet me now, at conferences or in courtrooms, tend to assume the arc of my career was steady from the beginning: fellowship, associate, partner, each step a natural consequence of the one before it, the way a success story is supposed to look when you tell it in a single paragraph at a networking dinner. I want to describe one specific year of it honestly, because I think the smoothed-over version does a disservice to anyone currently living through the messier, unglamorous middle of their own story. My second year of the appellate fellowship, Theo and Iris were both sick with the same stomach virus for 11 straight days. The kind that moves through a household of small children like a slow, relentless tide. And I was, at the same time, 6 weeks from a filing deadline on a habeas petition for a client who had already spent 4 years in prison on a conviction built on testimony a key witness had since recanted. I wrote most of that brief between 2 and 5 in the morning, the only hours neither twin was awake and needing something from me, running on the kind of exhaustion that stops feeling like exhaustion after a while and starts feeling like a permanent condition of being alive. The brief won, not on a technicality, on the merits, a full reversal. My client released 9 months later after the appellate panel found that the recanted testimony, combined with prosecutorial suppression of exculpatory evidence, had denied him a fair trial from the start. It was the first case I ever worked that made me understand, all the way down in my bones, what I actually wanted to spend a career doing. Not accumulating wins for their own sake, but using precision, patience, and a willingness to read every single page of a record twice, to correct things that had been built wrong and left standing because no one with the skill or the stubbornness had bothered to go back and check. The federal judge I clerked under, a formidable, soft-spoken woman named Judge Odalis Reyes, no relation, again, to the firm I'd eventually join, a coincidence I have never quite stopped finding funny, called me into her chambers the week the ruling came down and told me something I have carried with me every single day since. Ms. Voss, I have had a great many talented clerks come through these chambers. Most of them are talented because they are comfortable, bright, Well-resourced people who have never once had to build an argument out of nothing but stubbornness and midnight oil. You are talented in a different way. You build arguments the way a person builds something they cannot afford to have collapse. That instinct will serve you for the rest of your career, provided you never let anyone talk you into believing you got here by luck, instead of by exactly how hard you worked for it. I did not tell her that day about a china teacup, or a check with a signature on it, or a decade I'd spent quietly deciding whose name would eventually end up on a knife I'd been sharpening since I was 23. I only thanked her and went home and picked my children up from the sitter I could barely afford and made dinner and did it all again the next day and the day after that for years, long before anyone outside a handful of courtrooms had any reason to know my name at all. I did not go looking for Grant Holloway. I want to be clear about that, because it matters to how the rest of this happened. When Solara Kinetics walked into my office 8 months ago with their contract dispute, I did not know Holloway and Pierce would be on the other side of it. Bergman's U.S. counsel wasn't named in the initial engagement letter, only outside counsel to be confirmed. By the time I learned Grant would be lead, I had already built half the case, and I made a decision, sitting alone in my office at 11 at night, that I have not once regretted since. I was not going to recuse myself. I was going to win. On the facts, on the law, on 6 months of preparation deeper than anyone on the other side would expect from an opponent they didn't remember losing to before. If it also happened to be the man who let his mother buy me out of his life, that was not a conflict of interest. That was simply the case I had been training my entire career to be ready for. The recess after the morning session gave the defense 14 days to secure a new counsel, which they did, a competent but visibly rattled team from a mid-sized firm that had clearly been handed the case file that morning and told to make it work. But disqualifying Grant hadn't ended the underlying dispute. It had only removed the one variable standing between my client and a fair hearing on the merits. Over the following 6 weeks, in a discovery process that felt less like litigation and more like excavation, my team and Bergman's forensic accountants together pulled apart every layer of the technology transfer structure Holloway and Pierce had built. And it was during that excavation, going through 11 years of Holloway and Pierce's private client ledgers, that Bergman's own general counsel, eager to distance the company from Grant's conduct, voluntarily produced, to try to prove good faith, that I found Voss Fabrication. Not the modern entity that had been dissolved decades earlier, but the parent holding company that had terminated my father's contract. Kessler Marsh Industrial Holdings appeared 11 times across those ledgers as a long-standing private client of the firm, going back to a period that included the exact year my father's business collapsed. And then a set of internal memos from that era, the kind of documents that survive only because someone, decades ago, filed them correctly and no one ever thought to destroy them. I found a name attached to the file. Eleanor Holloway. Then a junior partner, 29 years old, handling what the memo described as client retention issues re subcontractor quality disputes. I want to be careful here, because this is the part of the story where it would be easy to make the truth bigger and cleaner than it actually is. And I promised myself a long time ago I would never do that. Not even in service of a better ending. What the documents showed was this. Kessler Marsh had been unhappy with a competing bid from a different, larger supplier who offered better margins and had wanted an exit from my father's contract without paying the termination penalty their existing agreement required. Eleanor Holloway, Then a junior partner 3 years out of law school had drafted the strategy memo that recommended manufacturing a quality dispute as contractual cover, commissioning a friendly inspection from an auditor with an existing financial relationship to Kessler Marsh, timed to produce a report that would justify termination without penalty. The memo does not use the word fraud. Memos like that never do. But I have read enough of them by now in 9 years of practice to know exactly what one looks like when it's dressed up in careful language for exactly this reason. So that 30 years later, if anyone ever found it, a good lawyer could still argue it was ambiguous. It was not ambiguous to me. I sat in my office at midnight with that memo in front of me and my father's termination letter from the same year in the folder beside it. And I understood, for the first time in 19 years, that the small business that broke my father's heart, and 3 years later, his heart itself, had not failed on its own merits. It had been engineered to fail by a 29-year-old lawyer building her career one quiet, deniable maneuver at a time. A lawyer who would go on to build an entire firm out of exactly that instinct. A firm that 30 years later would tell me, over a china teacup, that my family's kind of background made me unsuited to marry her son. I did not sleep that night. I sat with it for 3 days before I told anyone, including my own team, because I needed to be absolutely certain I wasn't seeing a connection that wasn't there. That grief and old anger weren't doing the reading for me. I hired an independent forensic historian, a retired SEC investigator who specializes in exactly this kind of decades-old paper trail, and paid her out of my own pocket rather than the firm's, because I did not want this to be Solara's case. This was mine. 6 weeks later, she confirmed everything. The auditor Kessler Marsh used in 1998 to justify terminating Voss Fabrication had, in fact, received a consulting retainer from Kessler Marsh's parent entity beginning the same month the audit was commissioned, a fact never disclosed to my father, who had believed, until the day he died, that his own quality control had failed him. It hadn't. He had been failed, deliberately, by the same woman who would later look at his daughter across a coffee table and ask whether a person from that kind of family was fit to marry her son. I did not bring this into the Solara case. It had nothing to do with electric vehicle patents, and I have never once let personal history contaminate a client's litigation. That is not a principle I'm willing to bend, not even for this. But I did, quietly, with the forensic historian's report in hand, refer the Kessler Marsh matter to the New York State Bar's disciplinary committee as a separate complaint attached to the same conflict of interest referral already opened against Grant. On the theory, which turned out, eventually, to be exactly right, that a disciplinary committee already looking hard at one Halloway would not be inclined to look away from a 30-year-old pattern involving the other. I want to say I felt triumphant when I filed that complaint. What I actually felt was something quieter and heavier, closer to grief than victory. Because for 19 years I had believed my father's failure was a story about bad luck, about a small business owner who simply wasn't strong enough to survive a hard year. And it turned out, the whole time, it had been a story about a woman deciding, with total confidence and zero consequence, that some families were simply not worth being fair to. I thought about my mother's calloused feet. I thought about carnations sitting untouched on a coffee table. And I understood, finally, completely, why some part of me had spent a decade sharpening a knife without knowing whose name would end up on the handle. It had Eleanor Halloway's name on it before I ever met her son. The Solara case resolved 9 weeks after the disqualification hearing, faster than anyone expected, Because once Grant was off the file, Bergman's actual general counsel, a pragmatic woman named Ingrid Voss Halverson, no relation to me despite the near-matching name, something we both found darkly funny during a late-night settlement call, took one look at the predatory clauses her own outside counsel had drafted and realized her company had far more exposure than upside in fighting us. Judge Castellano voided the reversion and exclusivity clauses as unconscionable as a matter of law, ordered Bergman to renegotiate the technology transfer payment schedule on standard commercial terms, and awarded Solera damages for the production delay caused by the bad faith negotiations, a number with 7 figures, which meant, for the first time in 18 months, my client's assembly line could finally start moving. Halloway and Pierce did not survive the fallout as cleanly. The disciplinary committee's investigation into Grant's conflict of interest widened, as these things do once investigators are actually inside the file room. First into 2 other matters where similar patterns emerged, then into general firm oversight, which is how the 30-year-old Kessler Marsh complaint I'd filed separately ended up landing on the same committee's desk within weeks of the Grant matter, instead of years apart the way I'd quietly hoped it might, giving Eleanor at least a little more runway before her own reckoning arrived. The State Bar suspended Grant's license pending a full hearing. A joint task force from the State Department of Financial Services and the Bar's Ethics Division opened a broader inquiry into Halloway and Pierce's client practices, spanning decades, once the Kessler Marsh memo became public record. 3 major clients quietly moved their business elsewhere within a month. The trade press, which had once called Grant the surgeon, ran a headline calling the firm's collapse the fastest unwinding of a New York institution in a generation. I would like to tell you that was the end of it, that I closed my laptop, watched the headlines, and felt the particular satisfaction of a decade-long account finally balanced. For a few weeks, that's almost what happened. Then, on a Tuesday morning in April, a process server arrived at my office with a petition for paternity and custody, filed in Westchester County Family Court by one Grant Halloway, naming Theo and Iris Voss as the subject minors. He had found out. I never learned exactly how, whether it was Eleanor, digging for leverage once her own world started collapsing and deciding a grandchildren card was worth playing, or whether Grant himself, humiliated and unmoored, had hired someone to trace me the way you trace an asset you've suddenly remembered you might still have a claim to. What the petition itself made clear was the theory that I had knowingly concealed his paternity of 2 children for a decade, that he had a constitutional right to a relationship with them he had been unlawfully denied, and that this was the sentence that made my hands go cold reading it in my own conference room. Given recent and severe instability in my professional and personal standing, arising from aggressive and ethically questionable litigation conduct, the court should consider an immediate custody evaluation in the best interests of the children. He was not simply asking to know his children. He was building a case, using my own disqualification motion against Grant himself and the disciplinary referral against his mother, twisted into a narrative that painted me as a vindictive, unstable litigator who had weaponized a business dispute to destroy a man's career and was now unfit to raise the children she'd used as leverage in that same vendetta. I sat with that petition in my hands for a long time before I let myself feel anything about it, because I have learned, across 211 cases, that the worst thing you can do when you're afraid is let the fear arrive before the strategy does. When I finally did let myself feel something, it wasn't fear. It was a very specific, very clean kind of fury, the kind that doesn't shake your hands, it steadies them. because I understood, reading that filing, exactly what was actually happening. Grant Holloway had lost his license, his firm, his mother's freedom, and every scrap of the reputation he'd spent a decade building. He had nothing left to negotiate with in the world he understood. Deals, leverage, contracts, courtrooms he could win through delay. And so he had reached for the only lever he had left, the one thing that could still make me flinch the way his mother once had. My children. I called my mentor, a retired appellate judge named Colette Bishara, who had taken me under her wing during my fellowship and had never once let me get away with a sloppy argument in the 15 years since. And I told her everything. The case, the memo, my father, the twins, all of it, in one long, unbroken sentence that took me almost 20 minutes to finish. When I was done, there was a long silence on the line, and then she said the thing I needed to hear most in that exact moment. Naomi, you have spent a decade becoming the best litigator I have ever trained, specifically in the one skill this man is about to test you on. How you fight when someone tries to use your own past against you in a room with a judge in it. You are not walking into that courtroom as his ex. You are walking in as counsel. Prepare it exactly like that, and you will be fine. I hired outside family law counsel to represent me formally, because I have never once believed that even the sharpest litigator should be their own client in a case this personal. But I sat in every strategy session as though I were second-chairing my own life, because in every way that mattered, I was. The Solera damages hearing, which I have compressed here into a single result, actually unfolded over 3 additional court sessions I have not yet described, and I want to describe them, because the final number my client received did not come easily, and because those 3 sessions produced a wrinkle in the story I did not see coming, one that complicated my understanding of exactly how much blame belonged to Grant alone versus the machine he'd been operating inside of. Bergman's new counsel, in an effort to minimize the company's own exposure, argued in the damages phase that Grant Holloway had acted essentially as a rogue operator, that his conflict of interest and his aggressive contract drafting reflected his own individual misconduct, not any instruction or awareness on Bergman's part, and that the company itself should therefore be shielded from the harsher end of the damages calculation, since a corporate client cannot reasonably be held responsible for its outside counsel's undisclosed ethical violations. It was a reasonable argument on its face, and for about a week I believed it might actually hold. Then, during a deposition of Bergman's Frankfurt-based head of North American acquisitions, a meticulous, soft-spoken executive named Klaus Reinhold, my co-counsel asked a routine question about internal approval processes for the contract's most aggressive clauses, the reversion provision, specifically, the one that would have handed Bergman perpetual ownership of any improvements Solara's own engineers developed independently. Reinhold answered honestly, in the particular way people do when they haven't been coached carefully enough to understand which honest answers are dangerous. That clause was flagged in our internal review committee, he said, through his interpreter, though his English was clearly strong enough that the interpreter mostly confirmed rather than translated. There was discussion about whether it was too aggressive to survive American courts. The recommendation for Mr. Holloway's office was that it would likely survive if the surrounding contract language obscured its full scope sufficiently, and our committee approved proceeding on that basis. I remember the specific silence that followed that answer. The sound of my co-counsel very carefully not reacting. The sound of Bergman's own attorney sitting beside Reinhold, going still in the particular way lawyers go still when a witness has just handed the other side something they didn't mean to give away. It meant Bergman's own review committee had known the clause was legally aggressive to the point of likely unconscionability, had discussed that risk explicitly, and had chosen to proceed anyway on the theory that obscured language might let it survive scrutiny. That was not a rogue lawyer acting alone. That was a company knowingly participating in the construction of a predatory contract, using its outside counsel's skill at obscuring the aggression rather than being deceived by it. I amended our damages claim within the week, adding a bad faith enhancement against Bergman directly, independent of anything specific to Grant's conflict of interest. Judge Castellano, reviewing the amended claim alongside the Reinhold deposition, was blunt in her assessment during the follow-up hearing. This court is not inclined to let a sophisticated multinational corporation hide behind its outside counsel's ethical failures when the underlying misconduct, knowingly drafting a clause understood internally to be legally aggressive to the point of possible unconscionability, required corporate awareness and corporate approval to occur at all. She increased the damages award by an additional 40%, a number that, when Priya read it aloud in my office, made her actually sit down in the nearest chair. I tell this part of the story because it matters to how I've come to understand what happened over that entire year, and because I don't want to leave the impression that the only lesson here is about one bad family and one bad son. Grant did what he did because it was profitable, and because he had spent his whole life being taught by a mother who'd learned the exact same lesson 30 years earlier from whatever taught her, that profit justified almost anything as long as the obscuring language held up in court. Bergman's committee approved the same math from the other side of the table in a boardroom in Frankfurt for the exact same reason. It is a much larger and older pattern than one family's cruelty, and I think, if I am honest, that understanding that scale is part of what made the eventual reckoning feel less like personal vengeance and more like something closer to actual justice. Not because it was bigger than me, but because it was never really only about me to begin with. Before any of the legal strategy, there was a harder conversation to have, and it could not wait for a hearing date. I sat Theo and Iris down on a Sunday evening at our kitchen table in Philadelphia, the same table where we did homework and ate cereal for dinner more often than any parenting book would recommend. And I told them, as plainly as I could manage, that their father had found out about them, and that he wanted to meet them, and that because of some complicated grown-up legal reasons, a judge was going to be involved in deciding what happened next. Theo, who was 10 now and had inherited his father's habit of taking things apart to understand how they worked, asked the question I'd been dreading most. Why didn't he know about us before? You said he knew you were pregnant. I had promised myself, a long time ago, that I would never lie to my children about their father, even when the truth was unflattering to me. He knew I was pregnant, I said. He didn't know there were two of you. And when things ended between your dad and me, I made a choice not to tell him more than that, because I was hurt, and because I was scared, and because I told myself it was easier for everyone that way. That was my choice, not his fault. And it's part of why we're dealing with a court now instead of just deciding things as a family the normal way. I want you to understand that clearly because it matters. Iris, 10 going on 30 the way she'd been since she could talk, folded her arms. Do you want us to meet him? I want you to have every honest chance to decide who you want in your life, when you're ready, on your own terms, I said. What I don't want is for a judge to hand him access to that decision before either of you is ready to make it, just because he waited until it was legally convenient for him to want it. That's the part we're going to court about, not whether he gets to know you exist. He already knows that now, and nothing changes that. It's about whether a stranger with a law degree gets to skip past 10 years of not showing up and walk straight into being your parent on a timeline that has nothing to do with what's actually good for either of you. Theo was quiet for a long moment, turning something over the way he always did before he spoke. Is he a bad person? It was, without question, the hardest question either of my children had ever asked me, and I owed them an answer that was true rather than one that was comfortable for me. I don't think he's a cruel person, I said carefully. I think he's a person who, when it mattered most, chose comfort over courage more than once, and let other people make hard decisions for him instead of making them himself. That's not the same as being evil, but it isn't nothing either, and it's part of why I need you to trust me to handle this the right way, even if it takes time and even if it's confusing. Iris considered this with the flat, assessing look she got from me, whether either of us liked it or not. Okay, she said. But if we do meet him, I want to ask him things, real things, not the polite version. When we get there, I said, you will get to ask him anything you want. I did not tell them that night about their grandmother, or about a company called Voss Fabrication, or about a memo written 30 years before either of them was born. Some truths, I had decided, belonged to a pace children set for themselves, not a pace a lawsuit imposed on them. But I did think, watching them clear their plates afterward, arguing about whose turn it was to load the dishwasher, exactly the way they'd argued about everything since the day they were born, that whatever happened in that courtroom, I was not going to let anyone make either of them feel, even for 1 second, like they had been born into the wrong kind of family. Not their father's mother 10 years ago over a china teacup, not a family court judge, no matter how the paperwork was styled, not anyone, ever again, as long as I had breath left to stand in front of them. The custody hearing was scheduled for a gray morning in late May, 6 weeks after the petition was filed, in a courthouse that could not have looked more different from the marble and mahogany of the federal building where I'd disqualified Grant 2 months earlier. Family court has none of that theater. It is smaller rooms, softer lighting, a judge who has seen 1,000 versions of exactly this kind of pain and has learned not to let any of them move her face too much. Judge Renata Okafor presided, a woman in her 50s with a reputation, among the family lawyers I'd consulted, for being unsentimental in the best possible sense. She did not care who had more money, better suits, or a more compelling origin story. She cared about a very narrow, very specific question, which was what actually served 2 10-year-old children going forward. And she had almost no patience for anyone who tried to make the hearing about anything else. Grant's counsel opened first, since he was the petitioner, and I watched him sit at his table in a plain gray suit that looked, for the first time since I'd known him, like it had been bought off a rack rather than built around him by a tailor who knew his measurements by heart. He looked smaller than he had in the federal courtroom, not softer, smaller. The specific diminishment of a man who has spent 2 months watching every structure he built his identity around get dismantled in public. His attorney, a family law specialist named Devin Marsh, made the argument I expected, that Grant had a fundamental legal right to know and parent his biological children, that 10 years of concealment had deprived him of that right unlawfully, that whatever happened between the adults was not the children's burden to carry, and that a phased reintroduction, supervised visits building toward shared custody, served everyone's long-term interest, including, pointedly, the children's interest in not being raised exclusively within the shadow of their mother's ongoing legal war with their father's family. It was a good argument. I want to be honest about that, because pretending the other side's case was weak does no justice to what actually happened in that room. If the facts had stopped there, a father who simply hadn't known, a mother who'd made a unilateral choice to keep that knowledge from him for a decade, Judge Okafor would have had every reason to grant exactly the kind of phased access Devon Marsh was asking for. And frankly, some real part of me, underneath all the anger, would have understood if she had. But the facts did not stop there, and it was my family counsel, a sharp, unshowy litigator named Priyanka Fields, who had spent 15 years in this exact courtroom, who laid out the rest of them with a precision I recognized immediately, because it was the same precision I'd have used myself. Your Honor, the petitioner's framing asks this court to view the last decade as a simple story of a father unknowingly kept from his children. The evidentiary record tells a more complicated story, and this court is entitled to the whole of it before determining what serves these children's best interests. She entered, one at a time, a sequence of exhibits. Text messages, recovered from an old phone I had kept in a drawer for a decade without ever quite being able to throw away, in which Grant, 6 days after learning I was pregnant, wrote to a college friend that he was trying to figure out how to make this go away without destroying everything I've built. A voicemail, saved on the same phone, in which Grant told me, 2 weeks before Eleanor's check appeared, that maybe it's better this way. Maybe we weren't supposed to work out. The termination letter from Voss Fabrication and the Kessler-Marsh strategy memo, entered not to relitigate a 30-year-old wrong, but, Priyanka argued, to establish, for the court's understanding of the family system the petitioner is asking to reintroduce these children into, exactly what conflict resolution culture that family operates on when its interests are threatened, because that culture is directly relevant to whether unsupervised access serves these specific children's safety and stability. Grant's face, through all of this, did something I had never once seen it do in 10 years of knowing him. It didn't harden, and it didn't perform composure the way it had in the federal courtroom 2 months earlier. It just fell, slowly, piece by piece, like a building losing structural integrity floor by floor instead of all at once. Judge Okafor turned to him directly, the way judges do when they've decided a moment calls for the person, not the lawyer, to answer. Mr. Holloway, I'd like to hear from you, in your own words, why this court should believe that a decade of no contact, followed by a petition filed within weeks of your professional collapse, represents your genuine desire to parent these children rather than, and I want to be direct with you, a search for stability of your own at a moment when very little else in your life remains stable. Grant sat very still for a long moment. When he finally spoke, his voice had none of the polish I remembered from a decade of watching him work a room. Your Honor, I won't pretend the timing doesn't look exactly like what you just described. I've spent 2 months losing everything I thought defined me, and somewhere in the middle of that, I found out I have 2 children I've never met, and yes, some part of wanting to know them is probably about wanting something in my life that isn't ruins. He stopped, swallowed, and for the first time in the entire hearing looked directly at me instead of at the judge. But that doesn't mean the wanting isn't real. I was a coward 10 years ago. I let my mother handle something I should have handled myself, because handling it myself would have meant standing up to her in a way I'd never once done in my life. And I told myself the easier version of the story so I could live with what I'd done. I know that's not enough to undo 10 years. I'm not asking the court to pretend it is. It was, I will admit, the first genuinely honest thing I had heard Grant Holloway say since a rainy doorway 10 years earlier. and it complicated something in my chest that I had spent a decade very carefully keeping simple. Judge Okafor was quiet for a long moment, tapping her pen once against her legal pad. Then she turned to me. Ms. Voss, I'd like to hear from you as well. Not as counsel, you have counsel for that, but as their mother. What do you believe genuinely serves these children right now? I stood, because old habits from 211 trials don't leave you even when you're not the one arguing the case. Your Honor, I don't believe these children should be shut out from ever knowing their father. I've told them that myself, directly, before this hearing was even scheduled. What I believe is that a relationship built on a father's convenience, reaching for his children only once every other structure in his life has collapsed, is not a foundation these children should be handed without real proof over real time that it's built on something more durable than his own need for ground to stand on. I'm not asking this court to punish Mr. Halloway for the family he came from. I'm asking this court to protect two 10-year-olds from becoming the newest chapter in a family pattern of using people as instruments the moment they become useful, and discarding them the moment they're not. A pattern I have personal and now evidentiary experience with, spanning 2 generations of this family and one of my own. Judge Okafor set down her pen. Thank you both. I am not prepared to rule from the bench on a matter this significant to 2 children's lives. I am ordering a full custody evaluation conducted by a court-appointed psychologist over the next 90 days, including individual sessions with both children, both parents, and supervised introductory visits between Mr. Halloway and the children, no more than 2 hours, twice monthly, at a neutral facility, pending the evaluation's completion. We will reconvene in 90 days with the evaluator's findings before this court makes any determination on ongoing custody or visitation. It was not the outright dismissal I had, somewhere underneath the strategy, been hoping for. But it was not the sweeping reintroduction Grant's counsel had asked for either. It was, I understood by the time we walked out of that courtroom, exactly what Judge Okafor had built her reputation on giving people. Not the ruling either side wanted, but the one the actual children in front of her needed, which was time, structure, and proof, instead of anyone's certainty. Before the custody petition ever landed on my desk, there was one more courtroom I have not yet described. Not a courtroom technically, but a hearing room in the State Bar Association's downtown offices, low-ceilinged and fluorescent lit in a way no marble federal courthouse ever bothers to be, where Grant's disciplinary hearing took place over 2 days in early July, 3 weeks before the paternity petition arrived. I was not counsel of record in that proceeding. The bar's own investigators handled the prosecution of the ethics complaint. But I was called as a fact witness, since the underlying conflict of interest evidence had originated from my discovery work. And I sat in a chair facing a 3-member disciplinary panel and answered questions for just under 2 hours about ledgers, recordings, and drafts I had, by that point, reviewed so many times I could have recited portions of them from memory. Grant's attorney at that hearing, different counsel than his family law team, a disciplinary defense specialist named Rosalind Achebe, who had a reputation for pulling licenses back from the brink in cases far more damning than this one, tried, gamely, to draw a distinction between aggressive but zealous representation of a client's interests and an actual ethical violation. The argument every disciplined lawyer's counsel makes when the facts themselves are no longer in dispute. It did not work. The panel's chair, a retired judge with a low tolerance for euphemism, interrupted Achebe's closing argument to ask, directly, whether zealous representation was the panel's term or Ms. Achebe's term for knowingly using one client's confidential commercial strategy to benefit an adverse client. And Achebe, to her credit, did not try to answer that question with anything but silence. The panel suspended Grant's license for 18 months, with conditions for reinstatement that included a full ethics retraining program and 2 years of supervised practice upon return. A suspension, rather than disbarment, largely, the panel noted in its written decision, because Grant had cooperated fully once confronted, accepted responsibility without attempting to shift blame onto subordinates, and demonstrated, through voluntary additional disclosures during the investigation, a level of candor uncommon in matters of this kind. I want to note that last detail carefully, because it is easy, in a story like this one, to flatten a person into either a villain or a redemption arc. And Grant, in the months I watched him move through consequence after consequence, resisted both flattenings more than I expected him to. He did not fight the suspension. He did not, as far as the investigators could determine, try to hide anything once the evidence made hiding pointless. He simply absorbed it, one hearing at a time, in the visibly diminished way I described earlier, not performing contrition for an audience because there was, by that point, no career left worth performing for. Whatever else I came to feel about Grant Holloway over the following year, I never once saw him try to lie his way out of the consequences once they'd actually arrived. That was new. I don't know whether it was growth or simply exhaustion finally outpacing the habit of self-protection he learned from his mother. I have come to believe, watching him with the twins over the following year, that it was probably both, in roughly equal measure, and that most real change in adults looks exactly like that. Not a clean conversion, but exhaustion finally making room for something better to grow in. The evaluation period turned out to be, in its own quiet way, harder than either courtroom had been. Courtrooms have a rhythm I know intimately: argument, evidence, ruling, done. 90 days of supervised 2-hour visits, twice a month, at a converted brownstone in White Plains with a sunlit playroom and a court-appointed psychologist named Dr. An Pham taking notes from a discreet corner, had no rhythm at all. It was just time, moving slowly, while 2 children I would have died for tried to figure out, in real time and without a script, how they felt about a stranger who happened to share half their DNA. The first visit was, by every account I got afterward, from Dr. Pham's summary, and later, much later, from Theo and Iris themselves, excruciating in the particular way first meetings between strangers who are supposed to already love each other always are. Grant arrived early, according to Dr. Pham's notes, and sat too still, and asked questions that came out sounding like a job interview rather than a father meeting his children. What subjects do you like in school? What are your hobbies? The kind of questions a person asks when the real question, the one underneath all of it, is too enormous to say out loud. Iris, predictably, tested him within the first 10 minutes. Why didn't you come find us for 10 years? Dr. Pham's notes recorded that Grant had gone very quiet, and then had said, I didn't know you existed until 2 months ago. And before that, I let my own fear keep me from doing the one thing that mattered most. And I've spent every day since finding out about you wishing I'd been braver 10 years ago than I actually was. Iris, per the notes, had considered this with her arms crossed for a long moment, and then said, That's a real answer, at least. Which was, from a 10-year-old who had inherited exactly none of her mother's patience for evasive men, about as close to approval as anyone was going to get on visit 1. Theo took longer to warm, and warmed differently, not through conversation, but through a shared interest neither of us had anticipated. Grant, it turned out, still kept a workbench in what remained of his apartment, a habit from a childhood spent, apparently, taking apart small electronics the exact way Theo did, a detail Grant hadn't known about his son, and Theo hadn't known about his father until, on the third visit, Grant brought a broken pocket watch and asked Theo, almost shyly, if he wanted to help figure out what was wrong with it. Dr. Pham's notes on that session were the first that used the word engaged instead of guarded. I would be lying if I said I felt nothing, reading those notes each month in Priyanka's office, watching secondhand as my children built something with a man I had spent a decade training myself not to think about except as an opponent. Some of what I felt was relief. Genuine, uncomplicated relief that neither of my children seemed to be inheriting the coldness Eleanor had shown me. That whatever else Grant was, he did not appear to be treating this the way his mother would have, as a negotiation to be won. Some of what I felt, harder to admit, was grief. For the version of this that could have existed a decade earlier, if a woman with a china teacup had never decided my blood wasn't worth including in her family. If a young man had found, just once, the courage to tell his mother no and mean it. Eleanor Holloway's own 90 days ran on a very different track. The Joint Task Force investigation into Kessler Marsh and a widening set of similar matters moved with the particular momentum of an inquiry that keeps finding more the longer it looks. 2 additional decades-old cases surfaced, both with the same pattern. A smaller vendor terminated under manufactured quality disputes, timed to benefit a larger Holloway and Pierce client. Memoranda carefully worded but ultimately unambiguous once investigators knew what they were looking for. In August, 61 days into the evaluation period, a grand jury indicted Eleanor Holloway on charges of conspiracy to commit fraud and obstruction related to the destruction of certain records once the investigation became public. Records her longtime office manager, faced with her own potential liability, ultimately testified Eleanor had personally ordered shredded the week the Grant disqualification story broke. I did not celebrate when I read the indictment. I want to be honest about that too, because it would make a cleaner story if I told you I opened champagne. What I actually did was sit alone in my study that evening, with the news alert still glowing on my phone, and think about my father, who never lived to learn that his failure hadn't been his fault, and about my mother, who died still believing the world had simply been harder on our family than it needed to be, for reasons no one could ever quite explain. I thought about how much I would have given, at 16, for someone to tell me the truth a year sooner, a decade sooner, in time for it to have mattered to the people it had actually happened to, instead of only to their daughter, decades later, in a courtroom that could no longer give either of them back what they'd lost. I let myself grieve that night, properly, the way I hadn't let myself in 19 years. And in the morning, I got up and packed lunches and drove Theo and Iris to their 4th supervised visit. Because whatever I felt about Eleanor Holloway's reckoning, it was not going to be allowed to touch how I showed up for my children that day. I learned about Grant's marriage almost by accident, in the middle of the evaluation period, from a line in Dr. Pham's notes that mentioned, in passing, a prior, significant relationship terminated approximately 4 years ago, which she'd asked him to discuss as part of understanding his capacity for stable relationships going forward. I did not ask Grant about it directly. It was not, strictly, my business, and I had promised myself I was not going to use the custody proceedings as an excuse to interrogate the rest of his life. But Iris, with the specific bluntness of an 11-year-old who had appointed herself the family's chief investigator, asked him about it herself on one of their visits, and reported the answer back to me afterward with the air of someone delivering breaking news. 2 years after I left New York, Eleanor had introduced Grant to a woman named Charlotte Ashford Reed, the daughter of a hedge fund founder and a socialite whose family had been photographed at the same charity galas as the Holloways for 3 generations. By every external measure, Charlotte was exactly the kind of partner Eleanor had once told me in her own living room that Grant needed. The right background, the right connections, a name that opened rooms instead of requiring anyone to explain it. They married 18 months after meeting, in a ceremony written up in 3 society pages, in a dress that reportedly cost more than my mother had earned in an entire year on the factory floor. The marriage lasted 3 years. Grant did not go into detail with Iris about why it ended, and I did not press him on it later. But what I eventually pieced together from a few careful conversations and from Priyanka's own knowledge of the family through the small, gossiping world of New York family law was a marriage that had never been built on much beyond the architecture Eleanor had designed for it. A partnership of institutions rather than people, in which Charlotte and Grant had, by most accounts, genuinely liked each other, without ever developing anything deeper than that, and had eventually admitted as much to each other over the course of a slow, amicable, expensively lawyered divorce that made almost no headlines at all, because nothing scandalous had happened, only something quietly and thoroughly unremarkable. 2 people who had married the way you'd sign a business contract, discovering, eventually, that a marriage is not actually a business contract, no matter how carefully Eleanor Holloway had structured the courtship. I did not feel triumphant learning this. I felt, mostly, a kind of tired recognition of exactly how thoroughly Eleanor had spent her whole life treating her son's most intimate choices as instruments of the firm's continued success. First, by removing me from his life because my background wasn't useful to her, and then by installing in my place a woman whose entire value to Eleanor lay in what her last name could open, rather than in anything about who she actually was. Grant had spent a decade being handed the version of love his mother found strategically acceptable, and it had cost him a marriage as thoroughly as her earlier interference had cost him the first 8 years of his children's lives. "Do you feel bad for him?" Iris asked me, after she'd finished relaying the story, watching my face with the particular scrutiny she reserved for moments she suspected I was hiding something. I thought about it honestly before I answered, because I owed her an honest answer, not a tidy one. "A little," I said. "Not because I think he didn't make his own choices. He did, every step of the way, and he's responsible for every one of them. But it's hard not to feel something for a person who spent his whole life being taught that love was a strategic asset instead of an actual choice, and only figured out the difference once almost everything else had already fallen apart around him." "That's very lawyer of you," Iris said. "Feeling bad for someone and still thinking he deserved everything that happened to him?" "Most true things are like that," I told her. "It's usually only the simple version of a story that turns out to be wrong." The reconvened hearing fell on a Thursday in late August, the kind of thick, humid New York summer day that makes even a courthouse feel airless. Dr. Pham's written evaluation ran to 41 pages, and I had read it 4 times before we walked in, each time finding some new detail I'd missed, the way Theo had, by the 6th visit, started bringing his half-repaired projects specifically to work on with Grant instead of alone. The way Iris had, in her individual session, told Dr. Pham that she didn't hate him anymore, which is different from liking him, but it's a start. The way Grant had, without being asked, begun attending a weekly parenting course typically recommended for reunifying families on his own initiative before anyone's attorney had suggested it. Dr. Pham's ultimate recommendation, when Judge Okafor asked her to summarize on the stand, was measured in exactly the way 90 days of careful observation should produce. "Your Honor, in my professional assessment, both children have shown meaningful, organic engagement with Mr. Holloway over the evaluation period, consistent with genuine relationship building rather than performance for the court's benefit." I do not find evidence that continued structured contact poses a risk to either child's well-being. I would recommend a graduated increase in unsupervised visitation, beginning with shorter periods and building over the next year, with primary physical custody remaining with the mother, whose home, routines, and caregiving history remain the stable center of these children's lives and should not be disrupted. I felt something in my chest loosen that I hadn't fully realized was still clenched. Not relief that Grant was winning something. I no longer entirely thought about it in terms of winning by that point, though I would not have admitted that out loud 90 days earlier. Relief that whatever the court decided, it was going to be decided on the actual, observed reality of my children's lives, not on either parent's narrative about who deserved what. Judge Okafor delivered her ruling from the bench without much preamble, in the unsentimental, efficient style I'd come to recognize from her over 3 appearances. This court finds that primary physical and legal custody of Theo and Iris Voss shall remain with the mother, Naomi Voss, consistent with the stability and continuity that has defined these children's lives to date. This court further finds, based on the evaluator's report and the demonstrated conduct of the petitioner over the evaluation period, that continued, graduated contact with the father, Grant Halloway, is in the children's best interest, and orders a structured visitation schedule to begin at 1 weekend per month, expanding at 6-month intervals contingent on continued positive evaluation, with both parties required to complete co-parenting counseling. This court declines to grant any request for equal or primary custody at this time, and reserves the right to revisit this order should either child's well-being indicate the need. It was not a total victory for either of us, and I understood, sitting there, that this was exactly the point. That Judge Okafor had never been interested in handing either adult in that room a win. She had been interested in 2 10-year-olds, and she had built a ruling around them instead of around either parent's decade of grievance. Grant did not smile when the ruling came down, and I did not either. We simply sat on opposite sides of a room that had spent 90 days slowly stripping away every easy story either of us had been telling ourselves, and let it be what it actually was. Not an ending, and not a clean one, but something closer to the truth than either of us had managed to offer each other in over a decade. Outside in the hallway, Grant caught up with me before I reached the elevator. His voice, when he spoke, had none of the polish left in it that I remembered from the man who once told a college friend he was trying to make this go away. Naomi, I know I don't get to ask you for anything else. You've already given more than I earned, just letting this evaluation happen instead of fighting me on every inch of it. But I want you to know, whatever happens with my mother, whatever's left of my career, I understand now what she cost me, that I can't get back with any amount of money or any court order. I had 8 years I could have had with them, and I let a woman I was afraid to disagree with take that from all 3 of us. That's not something I'm ever going to stop owing you for. You don't owe me anything, Grant, I said, and found, to my own surprise, that I meant it. You owe them. Every visit, every year, every time it would be easier to let the distance win again the way you let it win the first time. That's the debt. Pay it to them, not to me. He nodded, slowly, and for a moment neither of us said anything else. 2 people standing in a hallway, with 10 years of history between us and, finally, nothing left to argue about. For what it's worth, he said as I stepped into the elevator, you built something extraordinary out of what my family tried to take from you. I hope you know that. I know exactly what I built, I said, and the doors closed before I had to decide whether to say anything kinder than that. Eleanor Holloway's trial began in October and lasted 11 days. I did not attend as counsel. The disciplinary and criminal matters belonged to the state, not to me. But I sat in the gallery for the final 2 days, in a plain navy suit instead of the charcoal armor I wore to my own hearings, because I told myself I owed it to my father to see the end of this with my own eyes, whatever shape the end took. The prosecution's case was thorough in the specific, unglamorous way white-collar fraud cases usually are. Decades of paper, expert witnesses walking a jury through accounting entries most of them had never heard of a week earlier. The slow accumulation of a pattern too consistent to be coincidence. Eleanor sat at the defense table every day in a different, immaculate outfit, her hair set into the same architecture it had been in for 30 years, watching the proceedings with an expression that shifted over 11 days from contempt to disbelief to something that looked, by the final afternoon, almost like exhaustion. She did not testify in her own defense. Her attorneys, I heard afterward, had advised strongly against it, and for once in her life, Eleanor Holloway had taken advice she didn't like. The jury deliberated for 6 hours and returned a guilty verdict on the conspiracy and obstruction charges, though they acquitted on 2 lesser counts the prosecution had, most observers agreed, overreached on. The sentencing hearing, 3 weeks later, resulted in 4 years, with the possibility of parole after 2, alongside a civil judgment that would eventually strip most of what remained of her personal fortune, the firm itself having already dissolved by then, its remaining partners absorbed into other practices, its name quietly retired from the letterhead of a New York institution that no longer existed anywhere except in old case captions. I saw her once more in the courthouse hallway on the day of sentencing, flanked by 2 attorneys who no longer looked at her the way people look at someone whose favor is worth currying. She saw me too. For a long moment, neither of us moved. 2 women standing on opposite ends of a hallway, with 30 years of consequence stretched between us. Hers, mine, my father's, my mother's. 2 10-year-olds who had never met her and never would, if I had any say in it, which, as of that afternoon, I finally completely did. She spoke first, her voice smaller than I had ever heard it, stripped of the unhurried confidence that had once made a china teacup sound like a verdict. You did all of this. The disqualification, the memo, the indictment. All of it traces back to you. No, I said. You did all of this. 30 years ago, when you decided a small business owner's family didn't matter enough to be told the truth about why his company failed. And again, a decade ago, when you decided the same thing about me, over a plate of carnations you never even bothered to put in water. I only made sure the consequences finally found their way home. That's not revenge, Mrs. Holloway. That's just what happens to a debt, eventually, if you let it accrue interest for long enough. She looked at me for a long moment, and something in her face, I want to be precise about this because I have thought about it many times since, was not remorse. Not exactly. It was closer to genuine bewilderment, the specific confusion of a person encountering, for the first time in her adult life, a consequence she had never believed applied to someone like her. I built that firm from nothing, she said. Every choice I made to protect what I was building. You built it on other people's ruins and called it protection, I said. I hope wherever you serve this sentence, you find some time to think about how many families you decided weren't worth including in that math. Mine survived it. Not because of anything you did for us, in spite of everything you did to us. I did not wait for her answer. I walked out of that courthouse into a cold, thin October rain, and I did not look back to see whether she watched me go. I want to tell you the rest of this without the courtroom in it, because that is, in the end, the point of everything that happened. A year is a long time in the life of two 11-year-olds, and by the time the visitation schedule reached its final expansion, Grant Halloway had become, in the plain, unremarkable way that actually matters, a fixture, not a threat, not a stranger, not a headline. A fixture, the way any decent, present parent eventually becomes, if they show up often enough and stop asking to be thanked for it. He took the disbarment better than I expected, in the sense that he stopped fighting it and started building something smaller and quieter instead, a compliance consulting practice of all things, advising mid-sized companies on exactly the kind of conflict of interest safeguards that had ended his own career, which struck me, when I first heard about it from Theo, as either the most honest form of penance a person like Grant could construct, or the most on-the-nose one, and possibly both at once. He moved to a 2-bedroom apartment 40 minutes from us, close enough for the twins to stay overnight without a 2-hour drive attached to it, and he learned, slowly, the unglamorous mechanics of actual parenting. Packing the right snacks, remembering Iris's allergy to shellfish, understanding that Theo needed 45 minutes of quiet after school before anyone tried to talk to him about his day. I watched all of this from a careful distance, the distance of a co-parent rather than an ex, and I found, somewhere around the 8-month mark, that the anger I had carried for a decade had not vanished. I don't believe grief like that ever fully vanishes. But it had changed shape into something I could set down more easily than I used to be able to. Not forgiveness, exactly. I am careful with that word. I don't think Grant has fully earned it, and I don't think he'd claim otherwise if you asked him. Something more like an accounting that had finally, actually been settled, line by line, instead of left open and accruing interest the way it had for 10 years. The twins, for their part, adjusted the way children adjust to almost anything, given enough honesty and enough time, which is to say, better than either adult in the situation had any right to expect, and with a resilience that occasionally made me feel, watching them, that I had spent a decade protecting them from a wound they were, in the end, more equipped to metabolize than I was. Iris asked Grant, on one of their weekend visits, whether he'd ever tell his mother about them. He told her the truth, that Eleanor knew, that she had asked, in one of the 2 supervised prison visits Grant made in that first year, to meet them someday, and that he had told her no, not now, maybe not ever, because that was not a decision that belonged to him to make on their behalf, only to protect. Iris reported this exchange back to me, with the particular satisfaction of a child who has just confirmed that an adult passed a test she'd been quietly administering, and said, "I think he's actually trying now," in the tone of a verdict she'd taken a full year to reach and did not intend to revisit lightly. I did not correct her. I thought, privately, that she was right, and that being right about something like that, for a 10-year-old, was its own small, hard-won kind of justice. The Monday after the Solara verdict became final, long before any of the custody proceedings had even begun, Ashcroft Reyes's management committee called me into a conference room I had walked past 1,000 times without ever once being invited inside, and offered me equity partnership, effective immediately, along with a new title that would put my name on the letterhead for the first time in the firm's history, in a slot that wasn't alphabetical. I said yes. And then I went back to my office, closed the door, and sat with it for exactly 4 minutes before I opened my laptop and got back to work. Because the thing nobody tells you about the moment you finally get what you spent a decade building toward is how quickly the next case is already waiting for you, indifferent to whatever you just accomplished. The next case, as it happened, was a significant one, a coalition of independent battery material suppliers bringing an antitrust action against a conglomerate whose acquisition strategy had, over 6 years, absorbed or bankrupted nearly every mid-sized competitor in its sector. In a pattern my new associates and I spent 3 weeks mapping before we were confident enough in the shape of it to file. The trade press, when the filing became public, ran a short piece under the headline, "Voss Reyes's newest partner doesn't take small fights," which made Priya laugh out loud in the break room and made me, privately, think of a conversation on a bridge a very long time ago with a boy who told me he'd own the tallest building in New York and put a firm on the top floor. I had never wanted his building. I had wanted, it turned out, something quieter and more durable. My own name, spelled correctly, attached to work I would never have to apologize for. I updated my professional profile that evening, for the first time in years. Partner, Ashcroft Reyes, Chief Litigation Counsel. I stared at the line for a long time before adding 4 more words at the end. The same 4 words I had privately measured myself against since I was 23 years old and had nothing but a Harvard-adjacent scholarship and a factory-line mother's calluses to my name. Never lost a case that mattered. I left off the technical footnote, the 4 early losses, the 2 settlements that could be read either way depending on who was telling the story, because I had decided finally, at 34, that some kinds of precision matter less than the truth underneath them. I had lost cases. I had never once lost the thing I actually set out 10 years earlier to protect. A financial magazine ran a feature on me that autumn, one of those glossy year-in-review pieces about rising figures in commercial litigation, and the reporter, a sharp, persistent woman named Delphine Osei, spent 3 separate interviews trying to get me to say something quotable about beating my ex-boyfriend's family in court. A framing I declined every single time. Not because it wasn't true, but because it was so much smaller than what had actually happened that repeating it felt like a kind of lie. "People are going to write that headline whether you help me or not," Delphine finally said, during our 3rd and last interview, with the particular bluntness of a reporter who has stopped performing patients because the deadline is real. "I'd rather it come from something you actually said than something I have to reconstruct from court documents." I thought about that for a long moment, and then I told her the only version of it I was willing to have printed under my name. I didn't build a career to beat anyone. I built a career because I grew up watching my mother work harder than anyone I have ever met, for less credit than she deserved, and I decided a long time ago that the least I could do with whatever talent I had was make sure people like her stopped losing to people who'd simply been born standing closer to the finish line. Grant Holloway happened to be standing in my way this year. He won't be the last person like that I go up against, and he wasn't the first. He's just the one this story happens to be about. She used the quote almost verbatim, which surprised me, and ran it under a headline that had nothing to do with Grant at all. "The litigator who doesn't lose the cases that matter." A phrase close enough to the 4 words I'd already privately settled on for my own professional profile that I wondered, reading it on the train home, whether some version of that sentence had simply been inevitable from the moment I decided, at 23, standing outside my own apartment in the rain, exactly what I was going to spend the next decade becoming. Colette Bishara called me the morning the piece ran, her voice warm in the particular dry way she reserved for moments she was genuinely proud of me and didn't want to make a production of it. "You did the thing I told you to do 15 years ago," she said. "You let the work speak instead of the wound. Most people never manage that. Most people spend their whole careers still talking to the person who hurt them, even after that person's stopped listening. You stopped needing them to listen a long time before this case ever landed on your desk. That's the only reason any of it worked. I didn't have a clever answer for that. I just told her thank you, and meant it more completely than I'd meant almost anything I'd said in months. Because she was right. And because it had taken me most of a decade to become someone capable of hearing it without flinching. I still have the folder. Not the check, that became a trust years ago. And the paper itself I destroyed the week the Solara verdict came down, feeding it through my office shredder late one night, watching $300,000 worth of old shame turn into a pile of blue confetti. Along with, I liked to think, whatever was left of the power it used to have over how I understood my own worth. But I kept the folder, my mother's folder, the one with my father's termination letter and her careful, heartbroken notes about a lawyer she couldn't afford to hire. The one that eventually led me to a 30-year-old memo and a name I will never forget for as long as I live. I keep it now in the bottom drawer of my desk at home, underneath a stack of the twins' old school projects I can't quite bring myself to recycle. Not because I need the reminder of what was done to my family, but because I think there is something important in not letting a victory erase the cost that made it necessary in the first place. My father never got to see any of this. He died believing his own hands had failed him, when the truth was that someone else's hands had reached into his life and broken it on purpose, quietly enough that he never once suspected. I cannot give him back the 19 years he spent believing the wrong story about himself. What I can do is make sure his grandchildren never once, for a single day of their lives, believe the wrong story about themselves, that they came from that kind of family, that their worth is measured in old money and old rooms, instead of in exactly who they choose to become. On the evening after the sentencing, I came home to find Theo at the kitchen table with the guts of an old radio spread across a towel, muttering to himself about a capacitor, and Iris on the couch, halfway through a debate team argument she was rehearsing out loud to nobody in particular, already at 11, sharper and more relentless than most of the litigators I've opposed in federal court. I made dinner. We ate at the same scratch table we'd eaten at for a decade, and Iris told a joke so bad that Theo actually put down his screwdriver to groan at it. And for a while, none of it. Eleanor, Grant, the memo, the 10 years, was in the room with us at all. It was just the three of us, the way it had mostly been all along, the way it was going to keep being, regardless of whatever else changed around the edges of it. I put them to bed a little after 9, Theo asleep almost instantly, the way he'd slept since he was a baby, blanket squared with a precision I recognized as entirely his own and entirely mine. Iris, as always, had fought the blanket into submission and lost, one leg hanging off the mattress, mouth slightly open, the same unbothered sprawl she'd had since the night she was born, 6 minutes after her brother, and never once let him forget he'd made her wait. I tucked her leg back under the covers, the way I'd done 1,000 nights before this one, and kissed them both on the forehead. "Good night," I told them, the way I always did. My whole world. 10 years ago, a woman in a cashmere cardigan told me, over a china teacup, that I was not the kind of person suited to be part of her family. Tonight, standing in a doorway of my own making, in a life I built with my own 2 hands out of exactly the ruins she left behind, I understood something I hadn't let myself fully feel until that exact moment. She had been right about one thing, in the end, though not in the way she meant it. I was never suited to that family. I was suited to something better. To a small kitchen table, a debate team joke, a radio taken apart and put back together by hands that would never once doubt whether they belonged where they were standing. I went back down to my study. Outside the window, Philadelphia's lights blinked steady against a clearing sky. Nothing like the Manhattan skyline I'd once watched from a bridge with a boy who promised me the tallest building in the city. I didn't need his building. I had never needed it. What I needed, it turned out, had been sitting across a kitchen table from me the entire time, arguing about whose turn it was to load the dishwasher. And it had been enough, more than enough, from the very first night I carried it home alone. My phone buzzed once on the desk, a message from Priya. "Tomorrow's filing deadline confirmed. All exhibits ready. See you at 8. I typed back one word. Good. The same word I'd used to close out 100 nights like this one. And then I set the phone face down and sat for a while longer in the quiet, listening to the particular, ordinary silence of a house where everyone inside it was, finally, safely, entirely, mine to protect. Somewhere in New York, a firm that no longer existed had a story people would tell for years about how fast it fell. Somewhere in a federal facility, a woman who once told me my mother's calluses made me unfit for her family was learning, slowly and much too late, exactly what her own choices had cost. And somewhere in a small kitchen in Philadelphia, 2 children who would never for one single day of their lives believe they came from that kind of family slept soundly, undisturbed by any of it, exactly the way they deserved to. Never lost a case that mattered. Those 4 words were never really a tagline. They were the only inheritance I ever intended to leave behind, carved, one hard year at a time, into every late night, every folder, every step of a road I walked alone until, somehow, without my ever quite noticing the exact moment it happened, I wasn't walking it alone anymore at all. I should say something, before I close this out, about the part of my life that has nothing to do with courtrooms at all. Because I think a story that only ever talks about winning risks teaching the wrong lesson. That winning is the whole point. That a decade of vindication is the same thing as a full life. It isn't. And I want to be honest about the difference. 2 years after the Solera verdict, I started seeing a man named Elias Bramford, a pediatric surgeon I met, unglamorously, in a waiting room during one of Iris's routine checkups, where he happened to be consulting on an unrelated case and struck up a conversation about a battered paperback novel I'd brought to pass the time. He knew nothing about the Halloway case when we met, had never heard my name in any legal trade publication, and for the first several weeks of getting to know him, I found myself, almost involuntarily, watching for the moment his interest would sharpen into something calculating, the way I had once watched it sharpen in someone else a very long time ago. It never came. Elias remained, disappointingly to the part of me still braced for old patterns, exactly as uncomplicated as he appeared. A genuinely kind, unhurried person who liked me for reasons that had nothing to do with what I could open doors to, and who took 8 months to even ask what, exactly, I did for a living in enough detail to understand the shape of my career, because he had never once needed that information to decide he liked spending time with me. I introduced him to Theo and Iris carefully, slowly, on a timeline that had nothing to do with any court schedule and everything to do with my own certainty, which I had learned, the hard way, not to rush past for anyone. Theo, predictably, warmed to him over a broken bicycle gear system Elias helped him diagnose one Saturday afternoon, the 2 of them disappearing into the garage for 3 hours while Iris and I made a spectacularly unsuccessful attempt at homemade pasta, and laughed until our sides hurt at how badly it had gone. Iris, just as predictably, interrogated him directly within the first hour of properly meeting him, a habit I had, by then, stopped trying to curb and started actively admiring, and reported back to me afterward, with the same flat, assessing verdict she'd once delivered about her own father. He's not trying too hard, which is a good sign. The ones who try too hard are always hiding something. I have not married Elias, not yet, though it is a conversation we have started having, slowly, the way two people who both understand exactly how much a rushed decision can cost tend to have it. What I have built with him over these 2 years is something I did not fully believe I still had access to after everything the first 10 years taught me about love. A relationship built on plain, unremarkable honesty instead of strategy, where nobody is measuring anybody's family against a ledger of usefulness, where nobody has ever once, not for a single second, made me feel like I needed to justify where I came from before I was allowed to belong somewhere. I think about Eleanor Holloway sometimes, still, usually late at night when the house is quiet and old memories have nowhere better to go than straight at whatever's left undefended in my mind. I think about the particular, specific tragedy of a woman who spent an entire life believing love was a resource to be allocated strategically, the same way she allocated everything else: clients, contracts, her own son's marriage, and who is now sitting in a facility somewhere, stripped of the firm, the fortune, and very nearly the family, having never once, as far as I can tell, learned the actual lesson underneath everything that happened to her. I do not know if she ever will. I have stopped needing her to. Which I understand now is the real difference between the woman who walked out of that Park Avenue apartment 10 years ago and the one writing this down tonight. I no longer need Eleanor Holloway's understanding, her approval, or even her regret in order to know exactly what I am worth. I built that certainty myself, one case at a time, out of exactly the ruin she left behind, and no verdict she ever hands down about me from wherever she is now will ever again have the power to reach me. That, I have come to believe, is the actual ending to a story like this one. Not the moment the gavel falls, and not the moment the headline runs, but the much quieter moment, years later, when you realize the person who once told you what you were worth has simply stopped being someone whose opinion you're carrying around at all. Everything after that is just life, ordinary and imperfect and entirely, finally, mine. There is one more thing I want to put down here, not for anyone reading this, but for Theo and Iris someday, whenever they are old enough to want the full and unflattering truth of how they came into the world and what it cost to keep them safe inside it. I am not going to hand them this while they're still young enough to need a simpler story, but I am going to write it now, while all of it is still sharp enough in my memory to get right, so that when the day comes, I won't have to reconstruct it from a decade of distance and forgiveness that might, by then, have softened the edges more than the truth deserves. To my two whole worlds, you were never, for one single day of your lives, a complication. I want to say that first, before anything else, because I know the paperwork you'll eventually be curious enough to read, the petitions, the custody filings, the disciplinary records with your grandmother's name attached to them in ways that will be hard to read no matter how old you are when you finally do, will use words like that: complication, concealment, instability. Lawyers write in the language of risk, and you were, on paper, in certain rooms, treated as a risk to be managed by people who had never once met you. I need you to know that in every single room that actually mattered, you were the entire reason any of it was worth fighting for at all. I made choices, in the 10 years before either of you understood there was a father you hadn't met, that I still turn over sometimes late at night. I chose not to find your father when I could have. I told myself it was protection, For you, for me, for some version of dignity I wasn't ready to let anyone take from me twice. I have come to believe it was also, in part, fear, dressed up as principle, the same way your father once dressed up cowardice as consideration for his mother's feelings. I am not telling you this to excuse either of us. I am telling you because I think you deserve, eventually, two whole and honest parents instead of one villain and one hero. And the truth was always more complicated than that, for both of us, in different ways. What I am proud of, without a single reservation, is everything that happened after the truth came out. I am proud that neither of you, at 10 years old, needed a script to know exactly what questions mattered and which answers were worth accepting. I am proud that you built, on your own terms and in your own time, a relationship with your father that belongs to you, not to me, not to any court order, not to anything Eleanor Holloway ever tried to control from a distance. I am proud that you have both, in your own very different ways, inherited more of my mother's stubborn decency than anything from a family that once measured a person's worth in old money and old rooms. Someday you'll read the memo. Kessler Marsh, 1998, in careful, deniable language, describing exactly how to end your great-grandfather's business without ever once using an honest word for what was actually happening. I want you to understand, when you do, that the reason I spent a career building the exact skills required to find documents like that is not because I wanted revenge, though I won't pretend some part of me didn't want that too, for a while. It's because I decided, somewhere in the middle of the hardest year of my life, that the world has entirely too many families like the one that hurt ours, quietly deciding which people are worth being fair to and which people aren't. And I wanted to spend my one life making that math a little more expensive for the people who practice it. You are the reason I never let it stay only about anger. Every single time I wanted to let the fight get bigger than the two of you, one of you would ask me an unbearably ordinary question, whether we had milk, whether I'd seen your homework, whether it was your turn to pick the movie. And I would remember, all over again, that the actual point was never the courtroom. The courtroom was just the place I had to go sometimes to protect the ordinary, unremarkable, entirely wonderful life the three of us built at that kitchen table, one dinner at a time, for longer than either of you can currently remember. I don't know, writing this, exactly how your relationship with your father will look by the time either of you reads it. I hope, by then, it has kept growing in whatever honest direction it started growing in during that first supervised visit, when a broken pocket watch did more to build trust than any court order ever could. I hope, by then, Eleanor Holloway has become nothing more than a hard, complicated chapter in a family history you understand fully enough to have made your own peace with, on your own terms, in your own time. And I hope, more than anything else I could possibly write down here, that whatever else this letter tells you about where you came from, the one thing it makes unmistakably clear is this. From the very first night I found out there were two of you, tucked in together and already refusing to be separated by anyone, you were never anything less than exactly, entirely enough. Not because of anything you achieved, not because of any grade, any trophy, any court ruling that ever went your way. Simply because you were mine, and I was yours. And no one, not a woman with a china teacup, not a courtroom full of strangers, not a decade of hard, lonely years, was ever going to be allowed to convince either of us otherwise. All my love, always, Mom. A final note, written the same night, tucked behind the letter in the same drawer as the old folder. I keep thinking about the version of this story where none of it happens, where a woman in a cashmere cardigan simply says, 10 years ago, "Welcome to the family," and hands me a cup of tea instead of an appraisal. In that version, I never move to Philadelphia. I never build a career out of sharpened grief. I never find a 30-year-old memo that finally explains what happened to my father. Somewhere, I assume, there's a version of me who is happier, in some uncomplicated way, for never having had to become this specific, hard-won version of herself at all. I don't spend much time mourning that other woman anymore. I used to, in the early years, on the particularly exhausting nights when the twins were sick and the bills were tight, and the easier life felt like something I'd been cheated out of rather than something I'd never actually had a claim to. I don't feel that anymore. And I think it's worth saying plainly why, because I suspect somebody reading this someday will need to hear it more than they need to hear anything else in this whole account. The version of me who never had to fight for any of this would never have known, the way I know now, in my bones, exactly what she is capable of when everything is stacked against her. She would never have discovered that a factory worker's daughter with nothing but stubbornness and a scholarship could out-argue a man who'd been groomed since birth to win. She would never have learned that grief, handled with enough patience, can be turned into precision instead of bitterness. She would never have had the particular, hard-earned joy of watching two children she raised entirely on her own choose, on their own terms, to build something honest out of the wreckage of everything that almost kept them from ever knowing their father at all. I would not trade her life for mine. Not because mine was easy, it wasn't. Not for one single year of it. But because mine was actually earned, every inch of it, by a woman who never once needed anyone's cashmere cardigan approval to know exactly what she was worth. That, in the end, was always the only inheritance that mattered. Not the $300,000, not the name on a letterhead, just the plain, unshakable knowledge, finally settled all the way down into the center of me, that I had never once needed permission to belong anywhere I chose to stand.